Oops, sorry, go ahead.
I have no idea what's coming.
Well, that's okay. If we get a bunch of new documents, I will do this class updated next month.
Sounds good.
So, all right, I'm going to go ahead and get started as long as everyone can hear me. Let's see, we've got a few people. So what I first wanted to do was show everybody on here where we have a lot of document help on our private page. So you go into our private page all the way over here under files, and we have a wealth of information here, including things like listing presentations, buyer presentations, but most importantly, there will be, once we have a chance to update documents, there will be cheat sheets. And let me open this up here. So we're going to work off of the latest standard purchase agreement, which was from February, I believe the 12th. Always take a look before you fill out your documents. At the bottom of every page will have the date of publication. So that's very helpful. There are some times where the checklist might not have the newest, latest, and greatest, but they will be in our library. So we can pull them from there and dump them in. So I'm going to go ahead and get started off the standard purchase agreement. The blue are the lines that are the cheat. So I'm just going to go through this. The important part about the top is that for most disclosures, this will be, at least for the first 3 lines, the information that gets transferred. With the exception of, I just want to point out, we write the date that the offer is written, but for any addendums, meaning after we're ratified, any additional addendums or agreements or what have you, that will then be the date on top, the ratification date, not the same date at the top of the purchase agreement. This is just the date the offer is written. So we fill it out, full legal names. We always want to make sure that we ask that upon working with somebody. So it's not something last minute we need when we're trying to fill out a contract, especially if we're in a hurry. Go ahead and make sure you have the full legal names of your buyers and of course your sellers. And with your sellers, you are going to compare that. It's a good idea not only to compare it to the realist tax report, but go into any city or county website, look under the real estate appraiser section, and make sure that the names do match. If they don't, reach out to one of the mentors or leadership to discuss why, and we can move forward from there. So we have our name of our firm, we have our MLS number. Take directly from the MLS listing the name of the other firm. Sometimes people are operating under a team name within a firm. That is not what we want to put in here. We want to put in the name of the brokerage and then the brokerage number. Agreement to sell the property. This is where we put our full legal address taken from, you can take it from the MLS listing, but again, you want to compare that with the realist tax report. And then followed by the full address of the property. Coming down to the deposit, with anytime there are numbers involved in anything that needs to be ratified, we're going to make sure that we put them numerically and written out in words. Sounds tedious, but take the time to do it right. And then writing it out numerically, I'm just going to lead by example and tell you about mistakes I have made. I have left out a decimal point and wrote down that somebody was buying a house for over $1 million. Let's not do that. Double check your work here. The highlighted part here is definitely interesting. It used to be that we would check one and that's what they had to do. But what we were finding is if somebody wanted to change the way they were going to pay that EMD deposit, we had to do an addendum for the title company so that it allowed them to do that. Title company has reached out to us and stated, if we're not quite sure, it might be this, it might be that. Click as many as you need to, and then you won't have to do an addendum to follow up. And then here's where we're going to fill out either Jones Walker Lake or whatever settlement company that your clients are using. But never ever do we see our firm name on here. I'm still seeing some firms, they will hold escrow. We don't, we won't, we can't. So never put Coastal Town Realty or the name of an agent. We're going to put the closing attorney or title company. Here's where we want to mark whether or not the buyer has already paid or will pay. For the most part, we'll find that we're going to be checking will pay. But when you get into a scenario where a buyer has actually either been under contract or for whatever reason sent that money to the title company, the buyer has the option, if that contract falls apart, to leave the money with the title company. I usually recommend that. There is a possibility if the buyer was already under contract and say they got out on a contingency, that check might take up to, I try to set the expectation that the check might take up to 45 days to get back to the buyer. If the buyer is still shopping, just have them leave it with Jones, Walker and Lake or the title company, and that's where you're going to mark has paid. That's the difference there. Within 2 business days of the ratification date, this is really the only time I believe on any of our paperwork that we go off of business days. Every other timeline is 7 days a week, but here it's business days because it has to do with banking. So say, for example, you have ratified on a Friday morning, they actually do have till Monday night to get that deposit paid because of the weekend. So this is important if the buyer does fail to pay the deposit set above, or if any other check or funds paid by the buyer are dishonored, meaning they didn't cash, the escrow agent will let them know, written notice that to the buyer and seller. This is a timeline that needs to be honored or you are out of contract. Plain and simple. Set this expectation when you are doing your buyer presentation or buyer brokerage conversation. I like to actually bring this purchase agreement to both a listing presentation and a buyer presentation, so they are aware of what it will look like when you send it to them for signatures. And this is a good opportunity to explain to them, has to be paid in 2 days, this section here, and this section here says what happens if they're not. So again, we come down to writing numerically as well as in full words. Make sure that this is clear. There are plenty of times that through negotiations back and forth now, especially that we are seeing way more negotiating being done than we did in the last 3 years. Personally, I like to use a little bit of a small font because this can be crossed out, written over, written up here, written over here, written over here, and we have to leave room for initials every single time it's changed. And every single time it's changed, both of these will need initials. So coming down here, we do like to see if you can break this up by an actual amount instead of a percentage. And again, this amount gets changed as you negotiate a different purchase price. So as per what Lucy has written here, get specific amounts from lender and fill properly. Do not use TBD in these spots. After negotiations, make sure that they match the total purchase amount. There are times when you can use a percentage, but I like to only use that when we're going VA. It's just 100%. There is no down payment. Coming down here, this does not get filled out until everyone else has initialed and signed, and everything possible within this document has been negotiated, because once this is ratified, once this is signed by either party, no more changes will be made to this. And that's why it's important coming down here that the timelines and dates are based on this final ratification date. Again, why I said in the beginning that the date on top of this page here is not the date that you're going to copy and paste onto the rest of your addendums. It is going to be this ratification right here. Once you're ratified, it's a good idea to go back into Brokerment and put that in there. That just helps you when you need to find that quickly, especially if you are using a mobile version of Brokerment. So initials. Coming down here to settlement, very important here, the verbiage. If you are asking for closing costs, we need to be as specific as we can about everything that might entail. There are things that a lender could potentially say cannot be paid by seller, but for the most part, this is a good way, copy and paste, including debt reduction. This is something that sometimes we see on VA and FHA offers, where we're asking for them to help with a debt reduction that helps with the buyer's DTI. And then finished by any other costs, obviously, at buyer's sole discretion and approved by lender. Very important, sounds redundant, but it's not, covers everything, so you're not scrambling later. Coming down to the deposit, again, this is something that's definitely a good idea to review when you are in front of the buyer, but before you're even shopping, so that they have the expectation of what that EMD is. A lot of buyers, especially first-time buyers, they hear deposit and they think down payment. And we have to explain to them the difference and what's going to be the expectation, not only that they have to bring to the table at closing, but what will be out of pocket during the transaction. And this is the very first thing that is out of pocket. Coming down to the loan application section, this is here where you want to put the name of the lending company, the mortgage company, and the contact information. And in this part, you really do want to be specific with the loan officer's name and the best you can get for their direct contact info. For our local lenders that we have relationships with, we all have their cell phone numbers. Go ahead and put them on here. And then we see sometimes where a buyer is waffling about who they actually want to use. Maybe they're in the process of continuing to shop for a lender. If they are, like it says here, go ahead and list any potential lenders that they might choose from. A good, for instance, in this case, is if somebody comes to you and they are pre-approved through either Navy Federal or Veterans United, we're having the conversation with them about using a local lender and why. But just to make sure that it's covered here, we're going to put all the lenders that they might potentially be shopping for. Now, it says here, this will cover the need to ask permission to change. What I used to do in the past is put a strike through here where they must obtain permission. And I would put down here something to the effect of buyer to let listing agent and seller know with a pre-approval. What I like to do here now is just state pre-approval will be provided once lender is chosen. And as it says here, within 7 days. Again, by the end of the first 7 days, think of that as a loan contingency. They have to have chosen their lender, set that expectation so you're not 3 weeks in and they want to use a different lender because somebody made them some kind of a ridiculous promise. We all know that that happens. So lock that in here. Coming down here, buyer's failure to comply with provisions shall constitute a default in agreement. Again, point this out before you have ever put an offer in so that they're aware. Intent to occupy. Got a mark here, does or does not. With a VA loan and a conventional loan, the buyer has a certain amount of time that they must occupy the property. I believe it's 6 months, but I want to clarify that with a lender. So make sure that that is marked. This is for the purpose of investors. If they don't intend to occupy, it falls under the loan information because it does change the loan type.
Can I step in just a second?
Please, yes.
I do believe that the purchaser, if it's going to be a primary residence, has to take possession within 60 days.
Okay. Okay. And then is there a certain amount of time that they must have possession of the property as a primary? Or we don't really need to worry about that? That's more of a lender conversation.
You mean before they sell again?
No, before they intend to rent it.
Oh, I don't believe that's the case. If they've marked it as primary property, I do not know what that information is. I've never had anybody try to skate through with that.
Okay. Okay. I've seen circumstances come up on VA and FHA, but I will make a note of that to clear at our next conversation with lenders when we have to stomp the broker.
But if you're something like a seller possession agreement after closing, they need to be out and the buyer needs to be in within 60 days.
Okay. I like that. So again, initials at the bottom of every single page, not to be missed. Coming down here, exceptions to any kind of representations, any statements that are made as far as the seller selling the property. These are some examples of what those representations would be, or I'm sorry, exceptions to that. Short sale needing a bank approval, bankruptcy or divorce needing a court approval. Situations should be listed in the disclosure section of the listing as well as in agent remarks. I have to say, we all know that that doesn't always happen. Poke, ask questions. Sometimes they will say misleading things within the listing, but have that conversation with the listing agent specifically. If it's a short sale needing bank approval, sometimes they'll just state in the listing something like per bank approval or pending bank approval or purchase price already agreed upon bank approval. Those are short sale. And then if this is your first time doing a short sale, get with a mentor to walk you through. That is a bit of a different purchase, but should be represented in the listing. All right, this is where we get into information that the seller has to disclose, whether or not the property is on septic, whether or not it is subject to a waiver, whether this pertains to whether or not the sellers have made any additions to the property and have made any changes to the septic to accommodate for that, because septics are put down size-wise in relationship to the house. That is a overview of that. There are some really fun classes that some of the other leadership have done on septic information, and they're saved. I definitely recommend you diving in and taking a look at that information. Settlement possession, settlement to be on such and such a date may be extended. If this is not filled out, it does default to 10 days. When the market was moving very quickly, we were seeing a lot of people putting 5 days in here. I like to keep that for 10 days, but we need to be very clear why closing could be moved back. They're really, as I describe it to my clients, if it's a title issue or a loan issue. It doesn't cover if the buyer or seller is going on vacation. It doesn't cover whether or not they have a work issue. These are specific to loan or title issues. So if the closing does need to be moved back and it puts you outside that 10 days, if all parties agree, get an addendum signed by everybody, problem solved. Make sure that you're having a conversation with the lender about that, especially if it's a seller issue. The lender might not be aware of it. And we have to be very cognizant of any kind of rate lock that our buyer is in, if this is a longer close than, say, 60 days.
I'm going to interject again.
Yep.
And just say that best practices, we recommend not relying on those 10 days. Go ahead and do an amendment
As soon as you know, yeah.
as soon as you know, regardless of the fact that it's covered by the 10 days. Let's make sure all the I's are dotted and the T's are crossed, and that our people are the best protected we can make them.
Awesome. And to be clear, this 10 days is 10 days, not 10 business days, right? That's always been my experience.
Yes, correct.
Okay. Initials at the bottom. I do go over this section here with my clients because it is completely up to them who they choose to handle the settlement. I let them know the reasons why I feel confidence using Jones Walker and Lake, especially coming from a place where I've used other settlement companies, and I might tell a story or two about something that maybe went sideways and how we have extra protection by using Jones Walker and Lake. And the price difference is minimal, if any. So first-time home buyers, they absolutely have a tendency to go with our recommendation here. We would just want to be very open about the reasons we feel that way, because we're going to make them sign an agreement, a disclosure that we have a relationship with Jones Walker and Lake. I have found that people who are buying their second or third or more property, they might have a relationship with a different title company. That's fine. Get on the phone with the title company, get familiar with their website, get familiar with their closing costs. Any settlement company should be able to email or have on their website a breakdown of cost. And that's something that they can put side by side with what Jones Walker and Lake has to offer. But it is up to the buyer to choose the company. Coming down here, deed and title. This is as expressly provided in writing, representations and warranted made by seller herein, and all other provisions of the agreement shall be deemed merged into the deed delivered at settlement and shall not survive the settlement unless otherwise provided herein. What I find important about this is, again, we come back to whether or not they have disclosed in the MLS if it's anything different than a regular warranty deed. Special warranty deed could be a bank owned, could be an estate sale. We don't want to get into a situation where we're under contract and are then finding that out. Know that before you are making your offer. Initials at the bottom. This is where we talk about the survey. There's plenty of reasons to get a survey and there's plenty of reasons not to. I usually advise that the townhouse and condominium purchases, obviously, we don't have a need for a survey on that. The times that I do recommend that somebody roll it into the actual purchase is if they're thinking about putting up a fence or potentially a pool, because there could be easements for utilities that could prevent them from putting in a pool or a fence. Or even if there are easements that are in the way of putting in a pool, they can be moved by the utility company, but that is extremely pricey. I've had one situation where there were electrical lines under where they wanted the pool to go, and it would have been over $11,000 for Dominion to move that. So this is where we decide, have that conversation ahead of time. The other reason is that say you say waive and then you are under contract. If you haven't marked it here, they might not want you to be able to do a survey under the transaction, and then your buyer is going to have to do one afterwards. In my experience, if a buyer hires a company to do a survey afterwards, it can be almost double the cost than if you mark it here and have the title company reach out to hire someone to do that. If you have it marked here that they desire a survey, Jones Walker and Lake will order it, and it does come back within 11 to 14 days. If it is absolutely necessary for your buyer to have a fence or a pool, and they're going to need a survey done and you've marked it here, you can also make it an additional contingency so that your buyer is allowed to walk away if it doesn't, the survey shows it doesn't allow them to do a fence or a pool where they want to. So also elevation certificate, although that can be done as a result of looking into your flood insurance. If you already have a feeling that one's going to be needed and there is not one on record, that's another reason to mark it here. All right. So for the most part, I would say 99.9% of the time under prorations, we're going to be marked new financing. We don't see a lot of assumptions, and I don't believe that we as a firm do assumptions. So I'm going to leave a continuation of that conversation for another time. But we are not fans of assumptions here. They just leave too much room for lawsuits. All right, we're going to come down here to the financing contingency. So this has changed over the last couple of years. If you've been doing this for a long time and you haven't seen this, this is important. They've combined a couple of the categories. So you will have the purchase price in this section right here. As you negotiate that on the first page of this contract, you're going to need to mark and change and initial every single time that purchase price changes. That's very important. As it says here, make sure this matches the final agreed price. So actually, correction, you don't need to change it every time, just upon finalized agreed price. Coming down to conventional financing, it's not marked as the original purchase price. They're still allowed to get out as a contingency if the property does not appraise at the agreed upon price. But we find that with conventional financing, because we're usually talking about a higher down payment, that there's a little bit of fluctuation in what the lender can do with the down payment to make sure that there's not a need to get out, they can just readjust the down payment. For your cash buyers, they can choose whether or not they want an appraisal. I would say historically, they do not at the time of purchase. They might hire someone to do an appraiser at a later date if they're thinking of selling or they're thinking of doing work to the property and need to take out a loan against. Initials at the bottom. This was this one, the verbiage has changed over the last 2 years, I believe, with respects to these paragraphs. For any reason, the appraised value is less than the agreed upon purchase price. Buyer shall have 3 days from receipt and notification of appraised value to seller to either agree in writing, proceeding to settlement without regard to the appraised value, negotiate with the seller to find an acceptable agreement. If after 3 days the buyer has not agreed to proceed to settlement, regardless of the appraised value, the seller has not agreed to reduce the purchase price to the appraised value or an alternate acceptable to both buyer and seller has not been agreed to in writing, then either buyer or seller may terminate this agreement. If terminated, buyer and seller may execute a release with full refund of the deposit to buyer. So if the property does not appraise, and essentially, specifically for VA and FHA, if they're being asked to bring extra money to the table and they did not put in place an appraisal gap guarantee, they are allowed to walk away and they will get their deposit back. This is an extra layer of protection. Again, I encourage people to discuss this before going under contract with your buyer so they are aware of, they have an expectation of what could happen. But also we can show our value by saying we're going to protect you by either negotiating down, coming to an acceptable agreement, or I can protect your EMD and you can walk away. Property condition. I love this. You are not a home inspector. Do not address home inspection type items. Save that for the PICRA. So if you see things that you know will be dinged on a home inspection, you can leave it be. I do like to have a conversation with the listing agent. Say, for example, there are 3 windows in the property that are cracked. I will have a conversation with the listing agent beforehand. The listing agent is going to tell me verbally that that's going to be fixed. Here we go. They told me verbally, we don't have it in writing. And God forbid we have a home inspector who's having an off day. That's something that because I lay eyes on it, I can see it. And I've been told that they are going to fix it. We need to hold them accountable. And this is where we would do that. This is not where you put property to be cleaned or things like that. I see a lot of offers that come my way that state that. Coming down to, this is very important. We have a lot of, especially military buyers who are buying virtually, essentially. So we need to make sure that this is marked. They have or have not physically inspected the property in person prior to this agreement. If they have not physically inspected the property, we're going to mark has not. And there is an additional addendum that must be incorporated into this agreement, meaning signed off at the same time that this is signed off. That is a protection for seller, for listing agent, for buyer's agent. And in that document, it states everything that the buyer needs to be aware of on their end for having not seen the property in person. I've had arguments with other agents about whether or not a virtual walkthrough means they have physically inspected the property. 100% never. So, okay, this is where we're going to talk about the cap. Again, have this when you're having a buyer broker conversation, explain to them what the cap is. So the cap covers 4 separate items that fall on the responsibility of the seller. So I'm going to go over what those 4 things are, and then I'm going to come back up here to talk about the percentage that we're going to ask the seller to be responsible for. When the appraiser comes out to the property under A, and they're going to do a market value for the bank, they will potentially see any issues with the house that they will say the house might be at value, but it's conditional upon repairs. A lot of very common ones that we see are issues that have to do with wood rot, issues that have to do with health and safety of the house. So if you have waived a home inspection, there are times that an appraiser might ding something that even the buyer might have said that they're okay with, but you want to set that expectation that you can see it from yourself maybe when you've been in the property. And again, it's going to reflect up here when we talk about a percentage to ask for. As a listing agent, it's really important that you walk through a property, use what you know, sit through some of the appraisal classes so you can point some things out to the seller. I try to just have as much physically done as possible before going to market instead of waiting just for a smoother transaction. So when that appraisal comes back in, there's a tiny little section where it says this, and this are dinged and need to be repaired. And then the appraiser has to know when that work is done, and they will have to go back out. There is an occasional situation where the appraiser might not have to go back out. One of the number one things I see an appraiser calling out is the roof. If the roof is failing, if it's quite obvious, if there's a ton of rot, you can tell. If you have had the roof repaired, I have had certain appraisers take a picture of the new roof along with the invoice marked paid. But for the most part, an appraiser will have to go back out to the property. And that comes with an additional cost. Again, that can be reflected when we choose the number to go in the 1%. All right, so we come down here to what we call our M&T, our moisture and termite inspection and repairs. So depending on whether or not you're going to have a conversation with your buyer, if you want to have the seller obtain and seller expense, or whether or not the buyer will be obtaining and the buyer will pay for it, they don't have to be the same. You can have buyer shall obtain an authorized delivery at seller's expense for the actual inspection. The inspection these days is running between 90 and 110. So again, set that expectation. For the longest time, this was something that the VA did not allow the buyer to incur the cost of. I do believe that it is acceptable now for the buyer to do it. The main point that I will have the buyer pay for, but not necessarily, and I'm sorry, buyer obtain and pay for, is if I know that we are coming into a house that's going to have heavy competition on offers, right? It might only be 110, but you know that that good listing agent has run a net sheet and probably put that cost on the seller. So to make our offer look a little bit more attractive, there's a lot of ways we can do that. This is a minimal way, but it still leaves an impression. You really, truly want to make sure that if there's anything else that buyer is interested in having the moisture and termite company take a look at, this is a good list of things to consider. Decks can have a ton of moisture. A shed or storage unit, detached garage, pool house, guest house, especially if they plan on using them, and you'll know that because I find that if anything is wired for electrical and the buyer's super excited about it, go ahead and make sure that you have the moisture and termite inspection done here. You don't want them getting into the house and then discovering that you have a major issue, and perhaps, for a time period of a couple of months to get it repaired, they don't have use of such things. So go ahead and make sure that you mark down absolutely anything here that you might want to have them inspect. I like to put down here, match the timeline on the PICA. So if you've put down 7 days for the home inspection contingency, you're going to put down the same amount of time here. I have had to many times. I want you to be careful, because if you have marked here seller, and you go to the home inspection, you're the buyer's agent, and they don't have their moisture and termite person there, maybe at the same time, or you've been notified that they'll be there, make sure that they get that done within those first 7 days. I've had a couple situations where day 6, I'm reaching out to the seller's agent saying, hey, when do you plan on getting that done? And they have completely forgotten that it was the responsibility of the seller in that situation. We don't need to set anybody up for failure by waiting to see if they're going to do it. Go ahead and get in front of it, have that conversation with the seller's agent. Initial. This is very important for the treatment. If required, shall be performed by the company issuing the reports. Cost of treatment shall be at seller's expense, subject to the cap, which we're going to come back to. Any repair, seller shall correct in a workmanlike manner at seller's expense, subject to the cap, all standing water and damage identified in the reports prior to the walkthrough inspection. The selection of the company to make any repairs, if required, shall be at the seller's discretion. Buyer reserves the right to have the required repairs re-inspected. I encourage you to do that at or prior to walkthrough. Go ahead and do it prior, just again, for a smooth transaction. To ensure repairs were completed in a workmanlike manner. I've had plenty of conversations with buyers where they're not interested in a re-inspection and they're trusting that the work has been done because we have an invoice and we have a clear letter. It's a good idea to have it re-inspected, especially if you have something that's a rather complicated situation. This covers whether or the drinking water and septic, specifically well and septic, which we do have a decent percentage that happens here if there's any changes that need to be made or repairs to well or septic, that falls on the seller. And then finally, and very important, the walkthrough inspection. For doing this for a while, I like to do 2 walkthrough inspections, one a few days out. I don't have a problem actually doing that by myself, and I will take the time, make sure that any PICRA items have been covered, as well as the moisture and termite, make sure everything is working the way that it was the day you saw it, the way that it was the date of the home inspection as well. Typically here, we're going to mark that the seller shall be responsible for providing all utilities. Situations where I've seen that the buyer is marked are usually bank-owned properties and short sales. The utilities have been turned off. The sellers are under a hardship. And while you're under contract, you actually, as the buyer, can turn on the utilities in your name. A lot of the utility companies are agreeable to saying, I'm going to have it turned on for a month-long period to get the inspections done. And the inspections can be done at different times through those. But that's all I'm going to say about those. But for the most part, the seller is responsible for all utilities during the inspection. So let's come up. So we have those 4 items: walkthrough inspection, well and septic, moisture and termite, and appraisal. Again, these are covered by the cap, which the seller is responsible for. If this is a property that maybe has been on the property for a long time, they haven't lowered the price for a couple of different reasons, who knows, you might see a reason to actually raise the cap because you can see that it potentially is going to be more than 1%. For the most part, though, 1% or potentially a little bit lower. If you're looking at something like a condo or a townhouse where maybe they're not as responsible for the outside and we're in a competitive offer situation, I'll lower this to 0.5. But that, again, that was when we were in more of a speed market. It's a good idea to leave this at 1%. On the flip side of that, when you are the listing agent and you are making a net sheet for your seller, review this, and I like to buffer it. So when I run a net sheet for my sellers, depending on the price of the home that we're going to list at, I will even mark down 2%, especially if I know that we have an older roof, if I know we have an older, if we can see that there are some moisture and termite issues, especially if the property has been a rental and maybe not cared for a really long time. But 1% usually will cover it. Again, keep an eye on that roof. So, any questions on the cap question? All right, we will move on. Coming down to contingencies. So a lot of this section has changed to kind of simplify it. This has to do with our condo associations, our POAs, and our HOAs. It either is or is not a resale of a condo unit or located within a common interest community. They've made it a lot simpler down here, I think, in my mind. You're going to take the information that you see on the MLS as far as what the fees are, but there are times where it's off because they just made a change. We want to make sure that this number is accurate here. So I like to go on to a lot of these POAs and condo associations do have their information listed publicly these days. I've seen a lot of changes on the websites, especially in the last 4 years. Make sure you have the right monthly fee marked here. Yeah, here we go. This is one that we actually talked about in Stomp the Broker a couple of weeks ago. Discrepancy between what is a Horizontal Property Act or Virginia Condo Act. I'm not going to get too into that, but I like what's listed here. Call and confirm with the association. In the MLS, there should be a phone number for the association. If not, again, you can find it online. All right. So this is where we get into what makes this a contingency period. Buyer may cancel this agreement, within 3 days or up to 7 if agreed in paragraph 20, which we can change, after the date of ratification of this agreement, if the buyer receives the resale certificate, whether or not complete, or is notified that a resale certificate will not be available on or before the date of this agreement, or within 3 days, etc., after receiving a resale certificate, whether or not complete, or notice that a resale certificate is unavailable if delivery occurs after the date of this agreement. Buyer may also cancel this agreement at any time prior to settlement if a resale certificate is not delivered to the buyer. We don't really see that anymore. I used to see that a couple of years ago where it took a really long time to get that resale certificate delivered. We're seeing it more so. I'd set the expectation between 14 and 21 days. Essentially, the day that the condo documents drop to your email address, you're going to have them in your buyer's email address. You're going to let the buyer know that they've got 3 days to review all the information that is in there. We're not going to ask these days for this to be delivered physically because they have a tendency to be between 300 and 400 pages. So we're always going to opt for an electronic option here. A lot of the times what the buyer might not really be sure what they're supposed to be looking for. Couple of examples of this is if the property is sitting on a lake and the buyer thinks that they're going to be able to put a motorboat in the lake. A lot of times they have very specific rules. If anything, if they have a boat that uses gas, a lot of times they'll say that's not allowed. And a buyer can get out because of that. But it can also just be something simple, like if they have rules about what color the blinds or the front door needs to be, and the buyer feels like that's not something that they can live with, they are allowed to get out. And the way that I explain this to both buyers and sellers, because we tell them constantly everything is negotiable. What is never negotiable is what is in the condo documents or the POA documents. That is not something that we have any power over or can negotiate. So that's why this is a contingency and they're allowed to walk away. The day that this information drops into your email is known as day 0. So then they have three days after day 0, and each day ends at midnight to review and let the other side know, well, that's a separate document, moving ahead, everything is fine, they don't have any issues, or we're going to do a written notice of cancellation within those 3 days. If the 3 days pass and there's no communication or conversation about it, it is assumed that the buyer is in agreement and acceptance of everything that is in those condo documents. It's a good idea for us, if you've never taken a look at condo documents before, take a look at them, maybe get with somebody who's been doing this for a little bit longer. Take a look at the budget. We just want to make sure that that condo association is not operating in the red. And if they have any special assessments that are currently taking place that need to be paid past the closing date, we're not trying to make the buyer responsible for a major special assessment. That can be a roof, that can be windows, that can be a couple of different things, but that can be a large expense to the buyer that they might not know about. So we want to get into those details, discuss with the buyer what they're comfortable with. Also within the condo documents and POA documents, once the listing agent has requested those to be sent over, the condo association will actually send out their own inspector to take a look to see if there are any what they call violations. Sometimes it's as simple as they have a light out or they have a dent in the garage. Could be a multitude of things. Also, fences have a tendency to get dinged on those. You want to take a look at that, and I will go an extra step and write up an addendum stating each one of those violations and that the seller is responsible for fixing them by 3 days before, prior to 3 days before closing. Just a verbal confirmation that they'll do it, as we know in real estate, means nothing. So get it on record. Sometimes a listing agent might balk at that. Get it signed by especially by the seller, but by all parties, that they do agree to fix any violations.
I'm going to interject again here.
Please.
I recommend putting that in the other provisions section of your purchase agreement. Don't wait till there are violations and there's a contentious error to the transaction. While you're going in and you're getting everything agreed to, in other provisions, put in there that the seller agrees to remedy any and all HOA, POA, condo violations prior to closing, providing documentation 3 days beforehand. And then when that does come up during those 3 days, you know you've already got it covered. They already signed for it. They may not realize what they were signing, but guess what? Now they're on the hook in writing.
I love it. That's awesome. I'm going to start doing that. I love that. All right. Coming down to property inspection. Just let me stop for a second. Does anybody have any questions? All right, moving on. Property inspections. So we want our buyers to do a home inspection. It is their right. We all know that we get into competitive situations. I don't want to get too much into the conversation about saying that we're going to do a home inspection for informational purposes only. If you've never done that before, or you think you might be in a situation where that would be beneficial, have a conversation with a mentor, please, because it is our job to protect our clients. So this is where we mark that they desire to have a home inspection. And the home inspection, I'm looking for here. I thought it was supposed to say utilities shall be on for the home inspection. Not seeing that right here. Oh, pursuant to walkthrough items. If you're going to need an EIFS inspection, this is where you're going to mark that. Otherwise, you're going to mark NA. EIFS inspection is done. We don't have a ton of EIFS around this area, but we do have some inland. These are properties that are made with stucco or similar properties. We want to have that inspection done. It is expensive. It is worth it because you could be walking into a situation that you can't see with your own eye. If you've got holes where moisture has gotten in, you might have a terrible situation going on. You're not an inspector. So encourage your clients to shell out that money. It could save them tens of thousands in the long run. But an EIFS inspection around here, I have found to be between $1,800 and $2,200. I don't like to give a specific price for any inspections. I'll give a broad range. If the property is bigger than 3,000 square feet, it's going to be more expensive than that. So we have our lead paint disclosure, which is an additional disclosure attached, whether or not they want to have that inspection done. I had one done, I want to say about 3 years ago, and it was a smaller property, just a 3-2 ranch, and it ran about $450. We were able to get it done within the first 5 days of contingencies. So have the conversation about whether or not they want that done. The truth of the matter is there's a good chance if a house was built before 78, there's lead paint, but it is underneath years and years of other paint. I like to tell my clients, just make sure your kids and your dogs don't lick the walls. But again, they can have that as a contingency and get that inspection done. Other contingency possibilities: successful settlement of buyer's current property, subject to buyer obtaining acceptable pricing for flood insurance. This is really, really important these days, as well as bankruptcy, divorce, and probate. These are all things that can push back the timeline. So you can go ahead and set a contingency here for that, especially if the buyer needs to get into a place within a specific timeline. But be realistic, because if you are putting in an offer on any of these three, they can take longer than a traditional transaction. This is also where I will add a lot of the time a survey contingency for roughly 14 days. It doesn't have to be that, but I find that usually gets it done. Again, for the issue of building a pool or getting a fence down. So let's come to items to convey. Yes, we can look at the photos and based on the MLS, see what all of these things are or are not conveying. But also it's a really good idea when you're in the property. I like to take a look at how many ceiling fans there are because people have removed them. Go ahead and take a look whether or not that's a garbage disposal. It is supposed to be in the MLS, but it's missed all the time. So mark everything, because if you don't mark a refrigerator and you get to the property and the sellers have taken it, you don't have any reasonable recourse for your buyer. So I look at this section again as extra protection for our buyers. Take a look at the fireplace, look at what's there, make sure you ask for everything and make sure you have a conversation with the buyer. What do they want? What do they not care if it's there? For the windows, a lot of people will take curtains and drapes, but blinds and hardware, I always ask for. If somebody is absolutely in love with the curtains and drapes, go ahead and ask. Sometimes they are custom to the house and a seller is fine with leaving them, but sometimes a seller has whatever kind of attachment to them and wants to take them with them. But go ahead and mark blinds and hardware. Hardware is really important as well, because say they are taking their curtains and drapes and they go ahead and take the hardware because we didn't mark it, you now have holes in the wall. And that's not a good feeling. Nobody wants to walk into a home at a walkthrough and see that, or even after closing. Make sure you're marking for your trash and your recycling containers. They are, I believe last time I checked, $75 from the city if you don't have them. So make sure you ask them to leave. And as we all know, in certain sections of Chesapeake, they're not recycling, so you don't need to ask for that. Garage door opener, garage remotes, and any possible additional items that you can think of, even if you think it's not necessary to ask for, put it down here. If there's furniture, if there's any kind of anything that's in the home to make it handicap accessible and your buyer needs that, that's another place that I like to put this here. I ran a little bit long. Sorry, guys. I'm going to see if I can button this up within the next couple of minutes. Confirmation of brokerage relationship. 90% of the time, we're looking at listing firm is representing the seller. Selling firm is representing the buyer. We're potentially going to see some different scenarios a little bit more often than we have in the past. Make sure you know which one you're checking here. If you are unsure, definitely reach out, because a lot of these have the need for an additional disclosure. I'm going to leave that one as that, and unless there was anything that you wanted to add to that, Lucy.
No, I went over it during the meeting.
Okay.
Oh, and we can touch on it again when the new forms come out.
Yeah, that's one of those things that I have a feeling we're going to see a little bit of different verbiage specific to that section. Impossible, some additional disclosures. So aircraft nose join, we call this ACUS. It's the military noise, the jet noise that we hear overhead. It's different in different areas. I don't see that there have been a lot of changes to existing ones. Usually this is listed in the listing, but I do like to double check. I've seen some discrepancies where I'm writing an offer on a property and the listing says one thing, but when you go into a previous listing, it said something else. I'll actually jump into properties in that neighborhood specific to that street that have sold in the last year just to make sure. And then I'll actually go ahead and let that listing agent know, hey, you marked here 75 plus, it's actually 70 to 75, whatever, make sure it's right. And we're going to copy it down here. And that does require an additional disclosure. This whole section is about the additional disclosures. The Residential Property Disclosure Act This is the Chapter 27 that gets signed by your buyers as well as gets signed by your sellers. They don't sign the same one. They each sign their own copy. Disclose any and all relationships, either by blood or by marriage. If you think there's a chance that a relationship needs to be disclosed, just go ahead and do it. There's no need to play any games here. It can only come back to harm you. It can't help you if you hide anything. So put it out there. If you are related by marriage or related by blood to your buyer in any fashion, and I'll also put on here if it's been on the MLS that they have disclosed they have a relationship with the seller, copy that down in here as well. Megan's Law disclosure, that is also covered in the initial buyer brokerage disclosures, that they can do their due diligence to find any information that they're looking for online. I don't do that for them. They have to do their own due diligence. That's where we have the adulting conversation. Mechanics lien, this is something that will be discovered, hopefully, through the title company. And the good part about this is that they have 90 days to put a lien against the property from when the work was done. An effective lien for work performed prior to the date of settlement may be filed after settlement. Legal counsel should be consulted. I don't have conversations with my clients about this. I give examples of what it could be, but then they have conversations with the title company or an attorney about that. We all know that square footage isn't always 100% accurate. We are relying on what the sellers say. We're also relying on the tax documents, but there are times that work has been done to the property unpermitted. So we have to do our own due diligence as well. If there is a discrepancy, we'll see it come back on the appraisal. Let's come down here to property previously used to manufacture methamphetamine. This is the number one thing in our area that a seller must disclose if they know. Hopefully they have had it remedied. And if they had, everybody is ready to move forward, no problem. If they haven't had it remedied, I don't recommend anybody moving forward with an offer until you have a date that it'll be remedied. And then you can only close with proper paperwork saying that they've brought in the right company. It's very specific, the type of company that needs to come in and do this work. All right. If there has been any list pens against the property, such owner shall provide to a prospective purchaser a written disclosure that states so. Such disclosure shall be provided to the purchaser on a form provided by the real estate board on its website. So that's where we can take a look and see if there's any information there that we need to relay to the buyer about whether or not there's anything pending against the property. The brokerage fee, this used to be a separate document. It is no longer necessary as things have changed. This is where you have a conversation with your buyer before you have gone to look at a single property about your, we're going to try to call this compensation instead of commission here. Takes a little while, but this is definitely a better verbiage opportunity for us. And this is really where we show our value and our skill set. So say, for example, your compensation, the way you run your business is 3% of the purchase price. You have that conversation with the buyer. You let them know. Oh, wait, we've got something in the chat. Sorry. Oh, no problem. Have this conversation with your buyer because, say, for example, you have told your buyer that your compensation is 3% and that you can't really say like you're hoping that the property that your buyer falls in love with is offering 3%. What you can say to your buyer is, my total compensation is 3%. If we're looking at properties that have a lower percentage offered to the selling firm, I require you as the buyer to make up that difference. That will inevitably and should lead to a conversation about whether or not the buyer is comfortable with that, whether or not they can even afford that. Ways to make that happen, such as offering over the listing price and asking for a seller concession, etc. It's everything that you've heard us been talking about recently. You can also have a conversation with your buyer that if they cannot in any way, shape, or form offer to help with that, that you will only look at properties that offer your full compensation. There are some people, so say, for example, I have previous buyers and sellers, previous clients that I've worked with before. I will let them know that because we do have this relationship, say they've also sent family members your way. Listen, I will go down to 2.5. I can't go any lower than that. So if we're looking at a property that's offering less than that, I'm going to need you to make up the difference. And from what I understand, we're going to find out in July that whatever amount you put in here, you can't get more than that. So say, for example, you have put that you will accept 2% of the purchase price, and then the buyer actually falls in love with a property that's offering 3%. I think we're going to find out that we might not be able to get that 3%. So it's really important that we have this conversation about compensation before we go out to view properties. Again, I'm not going to get too into it because this is covered at some of our other meetings, but the VA has just changed the laws. It will go into effect in August that VA buyers will be able to contribute to their buyer's agent compensation. If you're interested in doing a flat fee, that's where you would put that here, but we're going to try to focus more on being a firm that does bring in 3%. That's a continual conversation. Initials. We've talked about default. I'm not going to get into dispute resolution because if anything, at the end of the day, if anything ends up in dispute resolution, we are dealing with attorneys. Other provisions, this is where, so what Lucy said earlier about putting in that any violations found by the condo association shall be taken care of and finished prior to 3 days before closing. That's something to put in here. If you're asking for a home warranty, this is a great place to put it. Be careful on the prices because they've gone up, plain and simple. Find out from the seller's agent whether or not they have a home warranty in place. Don't take a verbal anything about it, put it in here that seller has agreed to continue to pay on their home warranty for whatever, 6 months or a year, whenever that might expire. All right. Tax deferred exchange. This is otherwise known as a 1031. This is when somebody is using the equity from one property to use for the next property and not be taxed on that. Talk to a 1031 company. We have a few in the area that can help and guide you through it. It doesn't make a transaction any more difficult, but it's a great benefit to your buyer, especially if they're investors. I'm going to come down here to, we're going over miscellaneous. This comes back to what I was bringing up from the first page. The term day shall be deemed to mean any day of the week, Monday through Sunday, both inclusive regardless of legal or religious holiday. The term business banking day means Monday through Friday, except for the federal holidays. That's important. Explain that to everybody before you get involved in a contract. All right, coming down to the agreement to use electronic digital signatures. If both buyer and seller initial below, digital signatures are acceptable for use in this transaction. If both buyer and seller do not initial below, the digital signatures are not acceptable for use in this transaction. The following language is included for the sole purpose of determining the parties' agreement to accept digital signatures and is not required to be completed if the parties do not agree to accept digital signatures, etc. In this day and age, use digital signatures, plain and simple. In the blue below, initialing does not mandate use of digital signatures, but allows the use by either party. Always encourage initialing. The only times that this has come into play for me is I've had everybody actually sign this electronically, but you're going to deal with people of an older age who are not comfortable doing that, are not proficient in doing that, might require you to come to see them personally or meet up at the office to sign. Even if you know that they might need to do that at certain times during the transaction, you want to make sure that this is still at least electronically signed so the other party can use electronic signatures. And signature, initial. Coming down here, Make sure that this is all filled in properly. Take your time. I can't tell you how many times as a listing agent I've gotten this and this is not filled out properly. Things are in the wrong place. You might want to fix it for them, but as on the listing side, but as a buyer's agent, especially with our firm, we know what we're doing. We've been trained. Fill this out properly. I went a little bit long. Sorry about that. And we didn't get into additional disclosures, but I can do a separate video for that. Again, I want to wait until we get into July to see where we end up as far as what new disclosures we might have. If you don't know where to find your license numbers, it's on the DPOR website. If you go into an agent's name and click on additional licenses, it will show you their firm license number. Does anybody have any questions? I think most people have dropped off. I appreciate everybody coming today, and I will talk at you later. Have a great weekend.